They're at your disposal.
This meeting is being recorded.
Oh, that's good. And just a second. Greetings, everyone, and welcome to the conversation series on mediation, created with an aim and vision to promote awareness of mediation in the world around us, and to talk about mediation and other alternative dispute resolutions from the perspective of a common person. We continue with a short legal disclaimer. The views expressed herein are the personal perspectives of the speakers and may or may not represent the views of a larger professional community they belong to. The conversation series aims to provide a general overview of the awareness of the subject matter involved and may not be construed as a legal or professional advice in any manner whatsoever. This session is being recorded for wide circulation. Let me introduce the main speaker and the guest panelists for today's session on mediation, arbitration, and the role in dispute resolution. Meet the speaker for our session. Mr. Joseph George, a partner at George & George EDR Group, is a trained mediator, arbitrator, and certified HR professional, and has extensive experience mediating and arbitrating disputes involving labor, employment, and civil rights claims under the federal and Florida laws. Mr. George is also an EEO investigator, where he investigates claims of discrimination against a person on the basis of race, color, religion, including pregnancy, sexual orientation, and gender identity or national origin. As an EEO investigator, he serves as an unbiased fact gatherer, identifying and securing information through interviews of witnesses and review of written records. We welcome you, Mr. George. It will be a pleasure and honor to have you on board with us.
Thank you for having me on board. It's a great pleasure to be here and this great panel that you guys have put together today.
It's a pleasure. Well, we have Advocate M. Jagadish, currently managing the Bengaluru office of Tapas Law, certified mediator from Bangalore International Mediation, Arbitration and Conciliation Center, on the panel of ADR ODR International, accredited civil commercial mediator, and NCLT Hyderabad. He is a distinguished Toadmaster from Toadmasters International Communication and Leadership Training Organization, USA. Now, I am not aware of that, but you will have to tell me later. Okay. So he's a POSH trainer and visiting faculty in few reputed colleges and also a keynote speaker. He can speak English, Hindi, Kannada, Tamil, Telugu, and a bit of Malayalam. We'll have to learn that from you. Welcome on board.
Thank you.
Jagadish,
Thank you so much.
it's a pleasure. Ms. Kavita Bhatia, mediator, assistant professor in the Faculty of Law, the MS University of Baroda, Vadodara, pursuing PhD, invited as a research person to judge the national and international ADR competitions organized by law colleges and universities in both India and internationally. Many of her research papers have been published in UGC recognized and CARE listed journals. State coordinator of EMW magazine. She is also coordinator and honorary president of ADR International Club BSOLS. I'm not aware of that, but welcome on board. We have a student panelist today as well. Saloni Paliwal is a final year law student at Himachal Pradesh National Law University, Shimla. She is an ardent reader, researcher, writer, and holds great interest in ADR. So she is going to help me later on, right, Saloni? Her experience in the field of arbitration and mediation is vast, encompassing various international competitions and internship with arbitration firms. She is also a convener of ADR Society of HPNLU, Shimla. Welcome on board, Saloni, and welcome on board again, all of you. It's a pleasure.
Thank you, and it's a pleasure.
So, George, the topic of today, mediation arbitration. Since you are a mediator and an arbitrator and doing great work in this field, mediation is a facilitative process, and arbitration goes to a more evaluative and a kind of an adjudicatory process. So how do you combine both of them? From the perspective of a common person, how does that happen?
So mediation is, as you know, mediation is a voluntary process which both parties have to agree upon the mediation process in order to proceed to make it happen. My job as the mediator is to pretty much bring them together and let them see eye to eye on each other's perspective or each other's point of view. And then I have a soft approach on kind of working with both parties to mediate their cases. But when it comes to complex cases like construction, that's where it gets a little bit tricky because some construction, when you're mediating construction cases, you have to go on site to actually see what both parties is talking about. But mediation is a process that can be in any marketplace, any industry. Mediation can help resolve dispute, whether it's a divorce process, high network process, construction, retail, product liability, which has become an intricate part because even like eBay, Amazon, all these or dispute resolution process with their consumer base to resolve disputes so the consumer doesn't have to try to sue them constantly, which that falls into the litigation process. And then arbitration. Now, arbitration is completely different. Arbitration is more of the same setting as a courtroom, except it's more private, and the parties feel more comfortable doing it. And it's a quicker process for the parties, especially corporations who want to get back to doing business on a daily basis. So the arbitrators, such as myself, I personally always like the parties to send me out their whatever documents they want me to review. I like them to send it out to me at least 2 weeks in advance, so I have the opportunity to review all the documents. Because sometimes you have a case where I recently just had a case, and this one client sent me out over 200 and something documents. That's a lot of documents to sit and go through to get a point across. But you know, when they have legal counsel at the same time, the legal counsel has to draft everything up. So they want to make sure that they give the arbitrator everything, so we could actually base a good decision based off of the evidence that they present to us. So you could say arbitrator is pretty much judge and jury, because once it's binding, it's pretty much hard for a court to actually dispute or throw out an arbitration's ruling. So, but arbitration is very good for the parties, because sometimes if they want to do hybrid, and this is the new thing right now, hybrid is where you combine mediation and arbitration. So that if it doesn't work in mediation, then it transcends over into arbitration. So that's where it combines, and now we call it hybrid. And it's the same from negotiation. I'm a business negotiator also, so I combine the negotiation with the mediation because they sometimes can't come up with options on their own, but they don't want to go to arbitration. So what I'll do is I'll tell them, okay, so we'll close off the mediation process and we'll start the negotiation process, and I'll negotiate and come up with solutions on both of y'all behalf. And once the both parties consent to that, then I start negotiating on their behalf. I start to write little notes down on what each party wants and see if the other side is willing to give into that process. But both parties in mediation have to be willing to be there in good faith. That's the key part, being there in good faith. Because if you're not there in good faith, we can't assist them in resolving their dispute.
Very, very, very wonderfully explained. Actually, when you were talking, I did realize that how convenient it becomes, because when the parties are coming with a mindset to resolve their dispute, and then when it is a mediation process is going on and they're stuck somewhere. So now you turn into a negotiator. You know where the parties, the Batna and the Malatna is. So you can actually take them through the process of getting a better negotiated deal, especially in commercial cases. That's
Mhm.
a very, very good and sound perspective. Now, where can the challenge come? Where can the challenge come is from my point of view, from if I look at it from a mediator's point of view, the challenge can come in neutrality. That's where I mean, if the parties have actually told me something in caucus, now they don't want that to be available, that information to be available to the other party. Now, uh, when I become a negotiator, I am working for both of them, but I know everything. Do I remain neutral where neutrality can be hit? Can somebody take that idea?
If I
See,
may.
yes, yeah,
Yeah,
sure.
sure, please, ma'am. Yeah.
Yeah. Kavita, you can take. Kavita, you take.
Yeah. So, Sonal, you were talking about the neutrality of the mediator, wherein you are in a position wherein both the parties are actually shared some information, but then they are not wanting to share the same with the other party, and without which you won't be able to resolve the disputes. So, like we call this something as impasse, and then when impasse has been created, definitely some other mechanism of the idea, that is arbitration.
We've lost her. I think we've lost her. No, no issues. She'll come back. Yeah, she's here.
I'm sorry.
No problem. No problem.
I was
I think Kavita, you switch off your
the
camera.
hybrid form
Yeah.
will, yeah, the hybrid form rescue the parties wherein they have initiated mediation first, but then due to the impasse created, uh, because of which it is not actually going to resolve the dispute, and they may not be agreed on terms, there might not be a mediation agreement, so then they can choose arbitration, and then they can try to resolve the same with the help of arbitration, wherein arbitrator would take up the matter on the basis of evaluatory terms, wherein all the evidence is to be taken, and arbitrator would help them out to get the award settled. So this way, parties would get the solution to the problem. So I believe that hybrid form actually rescue the parties wherein uh, they are helpless, and even mediator is not comfortable taking the matter in the mediation.
Yes. I think that's where arbitrator has to come in, because mediation, they are not, like George said, they are not able to generate options there. So you take up negotiation, and after negotiation, maybe if you need to go at the adjudicatory process, then you will take into arbitration, where you might have to decide something on the merits of the facts or the case. Is that true, George?
Yes, that's true. And it actually works out for both parties because you have, as Ms. Kavita state that you have integral information from both parties that you could aid them in resolving their dispute. Because at the end of the day, we are all there to help them, to assist them in resolving their dispute. So if we just gonna mediate and just call an impasse, then their dispute is really not resolved. They're still stuck. And sometimes when you call an impasse and they go back home or go back to their business, sometimes that actually frustrates them anymore, and that's when it ends up in court. So if you could resolve it right there and then while both people is simmer down and they're starting to see each other's point of view, then using another tool as negotiation or arbitration is very good for both parties, because at the end of the day, we are there to help our clients and to resolve the dispute. So we have to use the tools at our disposal to aid in that process. And usually when I send out the agreement, I always have a hybrid clause into the notice stating that if you guys feel that you cannot agree or come to agreement in mediation, that we can pursue to arbitration as another tool to resolve it, as the arbitrator can resolve the dispute. And I usually let them know it will be binding. And once they know that it's a binding arbitration, then they know that you're making a decision for them. And sometimes, the arbitrator would actually make the same exact decision that one of the parties suggested. The arbitrator will make that same exact decision, and it's okay when we do it. But if the other party suggests it, for some reason they do not want to hear it from the other party. But the minute we do it, they're like, oh, I see exactly what you're saying. And I'm like, well, that's what the other party was trying to tell you so you guys could solve this dispute. But I think it's just because it comes out of the other person's mouth, they don't want to hear it.
Exactly. That's how disputes have escalated, because they don't want to hear the other party. That's where narrative mediation, changing the narrative, the role of a mediator comes in, because they are not willing to listen that, maybe that person is sounding something reasonable that person is saying. So that's because of their relationships going so sore, they don't want to listen. That's very wonderfully put. So, Mr. Jagdish, I wanted to ask you, what is the litigant's or a lawyer's role in, in these both the procedures? First, mediation, also sometimes, and then in arbitration, definitely there is a lawyer's role. So, yes, please.
Now, I just heard my learned brother and sister. They talked about mediation and arbitration. If you go little one step before, there is something called dispute, what you just now said. So when we have a dispute, we have something called ADR, alternative dispute resolution, which means there are 5 kinds of it. In a larger sense, there will be many more, but today we'll see only 5. So first one happens to be negotiation, which we already talked about it. Can be resolved through negotiation. Second one is mediation. Can we sit down and see, can it be resolved? The third one is arbitration. If mediation fails, can we do an arbitration? The fourth is conciliation, wherein a person who conciliates, saying, can we settle this court? The fifth and final one is judicial settlement, wherein all the 4 fails, judicial settlement will come. So now you asked me a question, what happens in litigations? In India, especially, because we have an amendment in CPC, which says any case, whatever you file, the court have to push the schmata for mediation. We have some, I don't know about how about in US, in India, they have court annexed mediation, wherein the people have been trained to mediate and they send it to that particular court annexed mediation. When it goes there, their 60 days time is given for them to come to some conclusion. As we know, mediation is no force. It's impartial. There's confidentiality to be kept. So it's again self-determined. So this is very, very important. ICS. Mediation revolves around this ICS. I stands for impartiality, C stands for confidentiality, and S stands for self-determination. If within the 60 days, if any party feels that, no, I see there's some impartiality, or there is no self-determination, I don't want to be part of this, or they feel that, I think that mediator is speaking to the other person, in my opinion, then they can walk out. Then it comes back to the court. Then the regular thing starts, trial starts.
Yes.
This is what happens in litigation.
Definitely. So, George, in your experience, in your vast experience, have you handled these kind of clients where they are just moving from one procedure to another and they're not getting satisfied, and you have had any tough clients like that? Because that experience really would make us also understand that it's everywhere around the world that happens. Mr. Jagdish is saying that. So any experience from your career that you felt that or maybe sometimes the mediator also feels that this case is not going to get resolved until unless somebody actively comes in, like an arbitrator comes in and starts the adjudicatory process, because they will be going round and round in their merry-go-rounds.
Yes, I've actually experienced that, and it seems like most of my cases have actually come from landlord and tenant dispute. That's where somebody wants to prove a point, and I say trying to prove a point could cost you in court. And it get heated because this person owes the landlord X amount of rent, but they feel that's their forever home. And because it's their forever home, they think that they have more rights than the landlord, because the landlord, he doesn't live there and they live there. So they feel like they shouldn't have to move out. And I had a particular case where this lady, there was a duplex. I can't state names, but the lady had a duplex and the landlord had several units inside there. And this lady decided to have a pig live inside of the house with some chickens. So I always tell this one to my friends because it's one of those weird ones where you go, huh? But she in the US, you can't, in certain areas, you cannot have farm animals living among the population. So, she's got citations from the government stating that, ma'am, you cannot have this animal here. This is not the area for this type of animal. She had the tub fill up with mud. It was a 2-bedroom, so she had one of the bathrooms fill up with mud. The chickens, just making a mess. And the landlord, he just wanted her out, and he tell her, I just need you to be gone. I'm not going to charge you for the 3 months of rent that you owe. I just need you to leave so I could clean up this place, because now that the government tried to cite her and they see they're not getting anywhere with her, they decided to cite him as the landlord, because now he owns the property. So now he's responsible for whatever she does. So now he's getting citations and money he's paying, to the city because of her mess. But she feels she shouldn't have to move, and then comes into another law. She tries to state where it's her emotionally support animal. so that gets tricky when somebody say that's an emotionally support animal. So but I pull her side and I turn to her and I start to, sometimes you have to bring them back to reality. Yes. And you give them a major reality check. And the only way you could deal with somebody like that is numbers. I turn to her and I say, okay, the landlord wants you out, but if you don't want to go and he decides that he wants to go to court, I shared my screen with her and I open up my Excel spreadsheet and I start to put numbers in. I say, for him to repaint the apartment, that's $1,200. For the plumber to suck the mud out the tub, he's looking at $3,000, because now he has to flush the lines out. That's $3,000. So now we're done already up to about $6,000 with her now. So I say, so now all the fees, he's going to ask for all the fees that he's getting cited from the city. He's already into $1,200 for those fees. So now we're already at nearly $8,000. I say, now if he goes to court, he said if he goes to court, he's going to bring his attorney in. And his attorney is going to probably charge somewhere of, $5,000 to $6,000, because he's going to do a deposition. He's going to do all these fancy legal stuff, because that's what attorneys do to rack up their money. And by the time I'm done with her, I say, if he wins the case, he can turn to the judge and say, Judge, I would like to seek attorney fees. And if the judge grants him attorney fees, then you're looking at somewhat of $15,000 to $20,000. She said, I'll move.
So now the emotional, that's really good. So that reality check is very much necessary. I think so. And so that's a classic example where mediation would have gone round and round in merry-go-round circles, like kids play this merry-go-round. That's or ringa roses. That's what, going round and round, round and round in circles.
Yeah. I would say here, there are kinds of mediation wherein we just facilitate our clients somehow, but then when we take up wherein the matters of consumer dispute or they are labor disputes, So wherein we can convince the parties that this is not facilitative mediation, but then it would be a evaluative mediation, wherein expert opinion would be considered, and then so this way somehow, Sonal, I believe that even mediation, the process which they have initiated on the first stage, they would be agree on appointment of the expert therein, and they may get the solution to that problem, because reality check is something wherein expert opinion you will be actually considered. And then as you said, they don't listen each other, but then they'll be listening to the third party. So that is really correctly you said.
That is a classic example. She's actually doing something wrong, and at the expense of a person who is paying for city charges, and she's not willing to see logic or reason behind it. So George had to, put it in numbers to make her listen and, reason. At least she could, when there are figures involved, and when a independent person who is also competent enough to give advice is talking, so that people listen to those. That's where I think arbitration, or that third person's role actually comes as an adjudicatory person or an evaluatory person, as you also pointed out, evaluatory mediation process, or like what George did. So, but that was a lovely experience. So, Saloni, any points from your side? Any from a student's perspective?
So yeah, if you see from the student's perspective, so now in India the things have been like on the route that say ADR and all, especially arbitration and mediation are coming to the general public, and they are getting into it more frequently than before. So if like I was a part of, during one of my internship, I was part of this Lok Adalat that they conduct for the bank, for the mediation between the bank and the people who have taken loan and they want to pay off. So that was the time when I realized that such ADR mechanism are like going to the ground level, because those mediations were conducted with the people who are living in village areas, and they were talked out, they were made, so that actually saves a lot of litigation costs and everything for the banks also. So those were the things that I came across, and that I got to know that yeah, now things are like going on another level for such area things, and people are not just resorting to litigation. In addition to that, for the students, things are rising, as now they are being taught ADR as a subject in the colleges, which was earlier a part of their syllabus as well. But now it has been on another level because of the competitions also that they get to be a part of. Nowadays, earlier it was all about moot court competitions, law students taking part into it and excelling it. But now with the time, there are mediation competitions, there are arbitration competitions that are coming up, that are being organized, and students get to participate in that and get a first hand experience of how one should conduct mediation, how they are supposed to act as a client, a counsel to such parties who are going for mediation. So that experience actually tell them that this this process is also as important as going to litigation. So when they go in this professional world, it is not just the litigation that they should suggest to their clients, or it is not just the litigation that is they are supposed to do, but also resort to such methods, because this is important to resolve the problems, and also it is important for the clients and the courts and the whole Indian judiciary system. So that is something that is giving them a great experience. There are also now with time hybrid competitions being conducted by the colleges. So there are MedArb competitions that actually give them also the experience of conducting mediation and arbitration simultaneously in the same problem and the dispute. So all these things are giving us a great experience and exposure to the practical world that we are going to face in the coming times. And I think that will actually eventually bring a difference in the whole litigation and the whole practice world for the law students, because that will give them a chance to learn more and how to deal with problems in the future.
Lovely, lovely exposure you guys are getting in colleges, because that is much needed now. Because when you move out from the law college, you yourself have to be, like, guided towards what cases you can handle outside court, what cases should actually go to the litigation when it is a matter of, a matter of law being decided, then it's better that it goes that way. But when there is no merits, or the case has not to be decided on merits, there it's clear, and it's just a misunderstanding or misconception, or the dispute does not involve any case of law or adjudication, then it is better that the law or the legal process is not invoked. And that becomes, when students are being taught, so they will take things in, it will go rightly. So, Joseph, that was really a good thing. Now, what are the challenges that you face in these kind of, procedures? Are there any challenges that you would have faced or you want to share in
Yes.
establishing?
My challenge is sometimes the attorneys. Sometimes I know attorneys who's going to see this are going to hate me for saying this, but the good ones will understand. Sometimes the attorneys are not always there in good faith themselves. Sometimes the attorneys make things a little bit more difficult for the mediator, and sometimes you have to turn to the attorney and tell the attorney, listen, this is mediation. I'm in control of this session. You need to simmer down. Because sometimes the attorneys, especially the ones that the court says, this has to go to mediation during pretrial, they say, you guys need to work this out in mediation, be in pretrial. So when some of the attorneys come in, sometimes they want to go to court. And I've had them inside the mediation saying, we're ready to go to court, and I'm like, wait, hold on. This can be resolved right now. If you would just sit back, calm down, take a chill pill. So sometimes it's definitely the attorneys. And I think here in the US, I think some of the bars that govern attorneys have heard enough from judges as well as mediators and arbitrators that sometimes the attorneys are not playing fair on their clients' behalf. So I think a lot of the different bars have enforced how some ethics on how attorneys supposed to act in mediation. So I think that's been helping out also. But one of my challenge is the attorneys, not the clients. Most of the times, most of the clients, they understand why you're there, and most of the time they're very respectful. But the attorneys, especially if the other client has another attorney, then it's like two bulls in a cage. They want to go head to head. Let's go to court. Let's see who's going to win this case. And it's not about them, it's about the client, So sometimes I have to remind I pull attorneys aside in a separate room and talk to the attorney separately and say, listen, I need to talk to you separately. And I pull him away from his client and away from everybody else in a separate room. And I've talked to him and said, listen, you're not here representing your client to the best of what the client wants you to do. And even though mediation is confidential, there's still a clause in the mediation says, and where disclosure is required or permitted by law. So if attorney is being unethical, I think that could fall into an area where you could say, okay, I could call, let's say, like where I'm in Florida, I could say I could call the Florida bar and file a complaint because you're being unethical and you're not there in the best interest of your client, and you're disrupting this judicial process. Because at the same time, even though mediation is an extension of the court, so it's still a judicial process. So you're disrupting the judicial process, and a lot of attorneys don't get that. So that's my greatest challenge. It's sometimes the attorneys make things a little bit more difficult for the mediator.
Yes, and that I think remains one of the challenge for the mediator uh, also. And I think sometimes the attorneys also are not able to, even if they are willing to help, they are also compulsion by, if even if one attorney wants to help, the other one will make things difficult. So there is some misunderstanding, and correlation is not established. We will. Kavita has raised her hand. Yes, definitely. Saloni, if you have to catch a train, switch off your camera, go to the train, and then start the camera. Don't
Yeah,
worry.
so
Yeah.
I just wanted to contribute here. Like
Yes.
in India, it is more about awareness amongst the lawyers and advocates and attorney, what you say, because they are considering ADR practitioners are the braid snatchers, and then they don't want to let it be resolved in mediation session or conciliation. I have observed when I took my students for lok adalat, wherein conciliation is a mechanism. I have seen litigants were uh, they are looking here and there. They were not properly guided where to go, what are the courtrooms, and then so here when my students have conversation with them, what exactly you are facing. So they were saying ki my advocate haven't informed that where to reach, and then who's the conciliator in our process. So this is depressing situation wherein the authorities are very much trying to get the disputes resolved through this lok adalat, wherein conciliation is the mechanism. But then advocates are not actually supporting their clients to get resolved, because they are considering uh, uh, this is something going out of my pocket, and my pocket would be affected. So this is again a really big challenge. So what
Yes.
I'm trying, yeah, yeah.
Yeah. Sure. Sure. Please continue.
Yeah, so what I'm trying as a teacher, I used to say my student, what do you want after completion of your graduation? Lying briefs in your cupboard, wherein you are day by day it is increasing, or you wanted to get it decreasing day by day, and you are actually helping your the society, getting dispute resolved, understand their vested interest. So that way I'm trying to get this profession ADR for professionals in this society. So like many of my students are saying, ma'am, please you start coaching mediation and arbitration. I of the opinion say ki, I don't want to be a mediator or arbitrator, because I want get more mediators and arbitrators in societies, so that we can see the society litigation free. So that's how my feeling is, and I really happy with the Saloni, that Saloni your what you said. I'm really glad to hear that students are now ready to be ADR professionals. So this is really a great turning point, wherein India would be seeing good ADR professionals and society would be litigation free. That's what my
I want to say something. First of all, George, it is a problem all over the world. It's a global thing that I would say the fine tuning between the mediator, arbitrator, and the lawyer is not happening. And people who are able to do that are really doing a great job. And like you said, that sometimes you have to reiterate that to a lawyer that you are not practicing, and this like that is where the laws are helping you also, that it is that you are not practicing in the best interest of your client, and you can be given, you can be informed, the bar could be informed. So that's a very positive difference that you guys in Florida have. We, as of now, I think Mr. Jagdish would be able to give a good viewpoint on that. We, as of now, do not have it. So even though ADR and litigation has to coexist, because there are crimes against the REM, against the larger section of the society, which have to be taken by litigants. So as much we require ADR professionals, we require good litigants also, who know their work, who know which case has to go through the court and directly will, take it. And there if a case which needs to be, which is a criminal or a crime and it's an offense, and it needs to go through the court procedure, if that goes to ADR, then the consequences can be more harmful. So I think Mr. Jagdish could tell something about that.
Yeah. Yeah. Now, I agree with what's happening right now. A lot of people, they do not get that idea that we are a mediator. To be frank, what happens, with the due respect, who are the mediator, at least in India, it is the advocates who got trained for 40 hours become mediators.
Yes.
Actually, I'm going one step ahead than what Mr. George said. Sometimes, as with the due respect, few mediators still think that I need to pursue something. No, as a mediator, my role is to see what is happening there. How can I be a catalyst to arrive at a solution? But sometimes we're all human beings. We get carried away by whatever we know, what we learned over the years as an advocate. Yes, I can push this, I can close this. No, as a mediator, my role is just be there as a stone. They let them say something, they'll, by the echo, they'll get the solution. That's what I believe in it. But what happens is, as a human being, we try to say something which is not a right approach. All right. Let's not talk about the advocates who come from their side. We ourselves, sometimes, not everyone, some mediators I faced in my own case, wherein I was the advocate for a family case for one party. I'm a little surprised that the mediator took it as if it's her case. No, you can't say anything. You are to hear both the parties. It is parties driven, right? Not the advocates driven or the mediators driven. It is the parties driven. So we are still, I would say, even though MedArb came way back in 1970, thanks to a person by name San Cagle from San Francisco, started MedArb for the first time in the history of mediation. In 1970, he settled a case called San Francisco nurse strike case, wherein he used MedArb for the first time, which is now we are all following that. You thought has seen 50 years, but still we are in nasal stage, I would say, at least in India. We are still evolving day by day, bringing new things, new thought processes. How can we reduce the court burden? All right. In India, we have a lot of pending matters. So only solution is ADR.
Yes.
ADR will really show us the way how the people will get what they want.
Yes, I do understand what you meant, Mr. Jagdish, but you have to give this credence also, that the fact that when we talk about India, yes, Saloni, I'll just give you 2 minutes. When you talk about India, we do not have lot of the quality of, like you're saying, 40 hours and then it's good to go. It's never good to go after 40 hours, and we know that. So that kind of training, which I think George would have got, or that they are doing out there, uh, that is a little different from how we are approaching it. So like you said, it's evolution is going on, so we really have a long way to go and a little difficult terrain. Yes, Saloni, what you wanted, you raised your hand.
So yeah, as we are discussing more of like the challenges that this MedArb process actually faces, there are a few things that needs to be addressed by not just the mediators or arbitrators on their part, but also the counsels, because when clients come to them, or when clients come to for this such processes, they are just the layman, and they don't know the whole process, and they don't know the whole aspect. So when they go for mediation or arbitration, they know this thing that arbitration is something where there will be a decision taken by the person based on the things, and they have to follow it. And for the mediation, it's more like the party driven process. When they combine both the processes, there is this thing where the confidential information shared by the parties in the mediation process, uh, that is like during the caucus or during the sessions that they conduct with the mediators, they do share some confidential information. But when they know that after this mediation, if this mediation does not get successful, there is going to be an arbitration, and this person who is sitting as a mediator will going to be an arbitrator for the session, they have that hesitance to share that particular confidential information. And that is the time when the role of the mediator and also the counsels come into active play, because they are required to make this thing like understood by the clients or the laymen, that there is the aspect of neutrality on the part of the mediator, and any information that is going to be told by you to the mediator will not be used against you during the arbitration proceedings,
Yes.
because that is the hesitance that they'll be having. At the same time, it's a challenge for the mediator as well, because they are supposed to not focus on such confidential information truly, and just discuss about the fact and the situation that is in front of them, and give their award or the decision based on that. So it's a challenging process for
Yes.
all of the parties, and they have to play their role quite actively, because if this hesitance come into play, and if this hesitance continues, then the mediation surely is going to fail, because the parties will be having hesitance to share their confidential information. But at the same time, they'll be having this pressure that if we don't resolve this dispute in the mediation, we'll have to abide by the decision of the arbitrator in the arbitration. So they'll be having the pressure to resolve the matter, but at the same time, they'll be hesitant. So that will not bring them on the good platform, and that will not resolve the matter in an actual scenario. So
Yes.
that is something that I think is a major challenge in this hybrid method.
Yes. That of course is there. First of all, you tell me, have you boarded the train?
No, I'll be leaving. It's a bit late, so I'm just leaving
So
in
you are
2 minutes.
taking care of that. Yeah.
Yeah, yeah,
So
sure.
she has a train to catch. So I'm more bothered that she should not. Yeah. Yes. That point, George. Actually, I also wanted to ask you that that the confidentiality challenge to the hybrid process and the neutrality challenge. Neutrality, you told that obviously they have to trust, but when we talk about the confidentiality challenge, do you when you are doing a hybrid mode, do you make a disclaimer like that? What she is talking about, that you will have to, if I will be continuing as your arbitrator later on and in the proceedings, so these things that you are telling me in the mediation will not be used in arbitration against you. Do you make that kind of a that kind of a challenge does come to you?
I have this clause inside there, but they understand that in arbitration, I'm there on their both behalf. I'm there to resolve the dispute. So they still have to give me the information anyway in order for me to resolve the dispute. Because as an arbitrator, I'm there as an outsider, let's say a judge, and I'm judging them based on the evidence that they give me. So the information that they give me in mediation, they're going to give me more than what they gave me in mediation because they want to win their case. So whatever that was holding back in mediation, they're going to give me excess of more, because now is where the attorney says, okay, we need to tell him everything because we want him to base a decision based on everything that we already have. So the confidentiality really doesn't bother the parties, because now they know they have to give me a lot more because I'm the arbitrator. Now I'm the judge. In mediation, we just shuffling conversations back and forth in mediation. So you're just moving one context over to the next person for it to understand what that person is saying, and then vice versa. But in arbitration, I need everything that whatever they're holding back or they're not going to tell me in mediation, now in arbitration, they're going to tell me everything. So it's a no holds barred when it comes to arbitration. Because in order for me to base a decision, they can't say, well, don't tell him this. No, they're going to be like, tell him this because I want to win now. Now he's basing a decision on everything that I tell him. So no. So the answer is no. There's no challenges and as far as that part in the neutrality or confidentiality.
Wonderful. That really saves it, because when they know that one procedure is not going to work, at least the second procedure is that step next is there, and that is the confidence that a person or a mediator also generates when they are mediating, that yes, if I am not able to help you in this procedure, next procedure is there where I will help you with my legal or professional expertise, that whatever is required. Because I think there are some cases where in where they say insurance or something like the, the I'm not able to get that word, where professional expertise are also required to get to the right decision. Yes, Mr. Jagdish, you wanted to say something.
Yeah, I just want to add for whatever my learned brother said. So there are two kinds of MEDAP. One is MEDAP pure, MEDAP
Yes.
opt-out. All right. So as he said earlier, that there will be a clause in the agreement saying that we will have a mediation. If it fails, we'll go for arbitration. Right? So the party knows that we're going to have a mediation first. If it fails, there is a settlement in mediation, then go for arbitration. In that also, the agreement clause will be saying whether the mediator will become an arbitrator, or if mediation fails, I'll choose another arbitrator. So it will be clear in the clause itself. So there's no confusion thereafter. So there are both are available. So as he rightly said, yes, if they agree for a MEDAP pure, yes, the mediator will become an arbitrator. Then you can close the issue. Sometimes, if the clause says so that MEDAP opt out, which means I know for sure is only a mediator, I can pull all the cards I have so that I can come a settlement. If it does not, then it will go for another person altogether, newer person who is an arbitrator. So the confusion will not be there. So it depends upon the quantum of the dispute is there. It will be there already in the spelled on the agreement itself. If it's going to be a very, very complicated issue, then I may have an opt-out. If it is a simple one, I may have a pure, which means an mediator can become an arbitrator. If it's a little complicated, then I not have a same mediator. I may have a different person who's an arbitrator. That's my point.
That you mean to say that choice should be available to the clients.
Client, it is in the agreement itself. When we create a clause, we call out there, is it going to be MEDAP pure or opt-out?
So Kavita, what you want to add to that? Like,
I'm just concerned about the actual qualities to be carried along as a mediator and as an arbitrator. What I believe is like there must be some restrictions wherein a person who's regularly conducting mediations, so the perspective which he carries while settling the dispute, just to get the solution to the problem, and it may be to be soft on the problem and hard on the problem and soft on the parties, but then the same quality won't be able to carry with a person if a same person who was a mediator in the case, he will be as an arbitrator. So this is something like let the mediator decide whether he would be able to carry this process as an arbitrator, because it is what I believe, there are different qualities which a person should carry as a mediator and as an arbitrator. Uh, there are qualities listed there in the MCPC codes, that a mediator should carry these qualities: patient listener, then a person who can summarize better, a person who can stimulate the session. So this is something like extraordinary abilities which a mediator carries, and that is utterly different what an arbitrator carries along. So can you please, George sir, tell that how to handle this thing, whether a person should, neutral party should decide, or party should decide uh, uh, whether to continue with the same person or not?
Yes, George. Like she wants to say that if a person, as an arbitrator or mediator, feels that this case requires some other person to adjudicate, because maybe I will not be able to do justice as an arbitrator, because my role as a mediator has been a different role. And like, have you had any kind of that kind of a case where you had to, you know?
I haven't had that type of case yet. I'm sure it's probably out there. I've had one that was close, but then the parties asked me to come back because I guess I could say yes. I was doing a high net worth case, and I was mediating that case, and it was a separation of assets. And working on that particular case, the parties felt like, being that I was the mediator, I might not be fully neutral when they couldn't come to a resolution. And then I tell them about the arbitration clause. Now we will transition to the arbitration. Then the attorney, again, it was the attorney, not the parties. And then after a while, they called me back in and said, no, we want you to arbitrate the case. And that was because the client had time to think and was like, okay, this arbitrator, which was our mediator, have a lot more knowledge of our case. We'll have to start everything back over from scratch. With this arbitrator, this guy has more knowledge of what we talk about. It'll be easier to be resolved that way. So again, it depends if they have counsel. Sometimes counsel want a fresh eyes on things.
Yeah.
Sometimes the client just want the same person because they done already built a rapport with that mediator, and they want that person to kind of continue on with them. So it's a yes and it's a no.
Yes, because that's what it's. I think your mediation skills that make a lot of difference there, because once you are able to get the rapport, with the parties, you get the confidence of the parties, and they would want to, okay, we are not able to solve it. So how do you can help? How best you can help us? So when that confidence is reached, I think they would want that same person to bring in the legal knowledge and decide for them, or maybe help them decide. It's, I think, not going to be, in those gas chamber, or like kind of a this thing that, now I am wearing this hat, I'm a mediator, now I'm switching over this hat, so I am going to be totally like this. It's not, I mean, we are all humans, so it's not going to be, I think that's what my belief is, that it's not going to be, the gas chamber or a bilkul sorry, I was saying that in Hindi. Total, total box type of a thing. So it's not that you are switching over to another hat, but when you have the knowledge of the case, then I think it would be more easier for you to go through the arbitration process, and the parties also would feel more comfortable that yes, George, your input would be good.
So I'd like to add on to that too. Now, it depends on the cases also. If it's a complex case, and let's say the mediator, it's a construction case and they try to resolve it through mediation. Now, because they cannot resolve it through mediation, now it has to go to arbitration. So now it becomes more complicated because now when it comes to arbitration, now you have to read the facts. You have to look at with construction, you're probably gonna have to look at blueprints. You're probably gonna have to look at different site conditions. So you have to go out and look at it. So you might need that knowledge now to do arbitrate that case. Mediating, you could move the information back and forth, but when it comes to arbitration, now you have to look at facts and you have to look at pictures, you have to go on site and things like that. So that person as the mediator, he might say to himself, listen, I could mediate this case, but I can't arbitrate the case because I can't read blueprints. I won't even know where to start. I don't know what a hammer is, much less a nail. You know, my wife fixes the dishwasher at the house. He might just say that. So
That's really a very good perspective, because I might be able to mediate, because there, I'm not taking the responsibility of the decision.
yeah.
Now when that hammer is in my hand, I have to adjudicate, and there comes a written agreement which is my responsibility. I'm going to sign it and say that it's my decision. So there somebody can say, it's not my cup of tea. It's not my.
As professionals, we have to know when to start and stop. We have to know our limits, and not because somebody's paying you. If you, okay, I can mediate for $900 for 3 hours. Okay, now if I transform into the mediator to the arbitrator, now that's gonna be an extra $2,000 because arbitration takes a little bit longer process because you're looking at the facts and evidence and things of that nature. Now you're gonna be like, oh well, you can't just look at the money. You have to look at, can I really do this? Because once you create that era of belief that I know what I'm doing to the clients, and then you go in there and now your arbitration award is challenged in court, and then you go into the courthouse and the judge looks at you and say, do you have expertise in this particular field? And you say, no, your honor. Then he's going to ask you, well, what was your base of your decision? And you can't say, well, I look at the blueprints and you don't know nothing about the blueprints, then that's grounds for a judge to throw your award out and give them a retrial. And now you could get penalized for that because you did not represent both parties well. You was being greedy. So that's my take on that part.
Wonderful, wonderful. So you do have laws to say that. So you, Mr. Jagdish and Kavita, we already have our answer that where we are lacking. That's precisely the reason why Mr. Joseph George is required, because that is a wonderful perspective, that if I do not have the expertise, I do not take that risk. I do not take
Definitely.
that responsibility which I'm not capable of. I have a
True,
right,
true.
I have a responsibility to say, no, I am not going to do that. How many of us will do that here in India? That's a question I
Actually,
have to ask that, but I really don't. I am fearful that people are going to kill me for
even
asking that.
I recall a provision wherein Sunil, Family Codes Act, wherein the judge for the family court can be maybe a socialist or a psychologist or someone from social reforms. So that way they do consider the importance of other stakeholders rather than judges for that position, because their counseling is very much required therein. So that way, mediator may not be well equipped with the knowledge, and so that there is a restriction not to take up the job actually, and it should be actually handed over to the someone who is qualified arbitrator. So that is in the interest of the parties, I
Yes.
believe.
And in the interest of the community, and in the larger interest of one's own self as a professional, you have a responsibility to not just earn money, by any means. It is a responsibility to grow oneself as a professional, as a human being. That kind of a feeling has to come now. It's high time. That's why it is uh, I mean, very, very commendable that you have told George that that's very much required in India also. That I can't say more than that. Although I've given a legal disclaimer, we are going to say something. But still,
Have you guys worked on high net worth asset disputes over in India with clients of high net worth?
yes, high net worth is taken care of by litigants only. Mr. Jagdish can point out more about that.
Yeah, we do. We do handle high network clients also. As you rightly said, what happens is if the order is not in favor of one person, which happens to be, definitely it can't be in favor of both the parties. The other party goes to the court and takes its own sweet time. Even though we have an arbitration award, that's been challenged on the same ground what you said, that he does not have an expertise or there is something, foul play played with the arbitrator. Then it goes for sweet some more years. So that is where we always say in India that to an extent follow only mediation so that there is no appeal. Whereas arbitration got another round of litigation.
Yes. And when I was doing my ADR course also, this was one of the things that why ADR has not, international arbitration has not been able to make a big impact on the global scene is somewhere that we have a lot of pathways to an arbitral award being challenged. And like what you said, George, that when an arbitrator or when a mediator will refuse that, no, I do not have the expertise, I will not take this, because when you take it and then again it gets challenged, you have made money, but then there is nobody stopping you. Like you said, you can, we don't have, I think, or I will not comment upon whether we have a procedure to get penalized for a wrong arbitral award. Uh, there are loopholes there also. I will not mention that. So that responsibility, when it comes on to me as a human being, and I'm responsible enough to refuse that, that's where things for a whole society change, for a whole community change, for a whole country change. That
Yes, here in the US, the only time that awards are overturned by a judge is on narrow circumstances. Like let's say um, the arbitrator received money from one of the parties. He was a family member and he didn't disclose that he and this person was grew up together, um, or receiving gifts. Gifts is another thing that they don't. It's zero tolerance for it. So let's say that you awarded, let's say a particular company, you award them, and then they send you out, let's say like a new Maserati. You have to refuse that gift because now if that losing side see you got the gift, or got wind that you got a gift from the company, they're gonna say, oh, he was in favor of the other person and they present him with this car. So you have to refuse it, and that's part of the ethical rules of arbitration here in the United States. So you can't receive gifts from the parties, and usually you try your best to not have any type of communication with the parties before and after it. If there's any type of communication, I've had where clients have called me up and tried to explain to me the case before the hearing, and I've actually called the other side and tell them, hey, this other side called me up, try to present the case, but I let them know I shut it down. I did not interact with the person. So we as the arbitrator, in order for us to keep our license or certification, depending on where we at, we have to be able to not just throw things out the way and say, oh, well, he called me, I handle it. I don't need to tell the other side, because you need to tell the other side that this person did call you, because it could show that you show favoritism depending on how you rule on the award. So you don't want to give any type of perspective that you was in favor of this other person because of a conversation that you have on the phone. Because now when you go to court, the other side could pull a subpoena and say, I like to subpoena his phone records for whatever reason to see what they actually talk about, because I feel like they had a conversation going on, and that's why he ruled in favor of this other person.
Wonderful, wonderful. So we see what the difference is. That, that it makes totally going by the book, by the highly professionalism. That's where we have to take things to, that if we want to make a change. And that, I think, makes a lot of difference, because as you were saying, that there is no confidentiality challenge, because as far as our practice here, there will come a confidentiality challenge when we are, because frankly speaking, when we go to the courts, uh, or as Kavita was also saying, that when we go to the arbitrator, we might not want to disclose certain things, and that we might want to disclose in mediation. So there comes a confidentiality challenge, because people themselves might not be very fair and just in dealing with things. So here it becomes, otherwise, like George, you are saying that there is no confidentiality challenge. In fact, they would be more than willing to tell about their case, because now they know that I'll be judging and I'll be able to help them. So that is the difference here. Really, that's that's too good. So MedArb, if it has to happen the way, then we have to go by the book. We have to be very honest and very professional in our ways. That's what I could take away from whatever our conversation has been. Any closing comments? Because this conversation has been the biggest. We've really surpassed the 1 hour.
Yeah, so then I would say, in case of mediation, it is party and party only who will be taking to the solution. If we choose made up, again, party would decide, if because if party is not carrying faith in mediation, they haven't resolved the dispute, that leads the process to the arbitration. So I believe it is party and party only who will be actually deciding where to go and how to carry this process. The neutral party would help them out in whatsoever manner it may be, but then it is party only who will be deciding what to choose.
Yes, definitely. That remains. But as any closing comments by George?
Yes, I would like to say we definitely got to educate the public a little bit more on the process. That way, because the more education we educate the public on the process, the more they trust the process, the more they want to come out. And when they sit down with a mediator or arbitrator, they already know what the process is about. So that way we can help them know effectively. But if we don't educate the public, they can't come to us. The public still don't know, which I don't understand why, because mediation and arbitration has been used from Egyptian times. And still up to now, people still don't know that mediation and arbitration is an alternative to the system. So even here in the US, I'm one of the mediators and arbitrators that is pushing education to the public. So they come to the arbitrators and mediation before they even go and file a case in court. Because right now, most of the court system actually sends the cases to mediators and arbitrators before, even some public governing bodies say, before you come to us and file a case in court, you have to go through alternative dispute process. And that's what the government agencies have decided, because they could get bogged down with get flooded with so many cases that they can't handle every single case. I mean, it's a big role out there, and everybody feel like they have a dispute that should be handled by the courts, but sometimes their cases are so simple, it could even be handled by their neighbor. Um, so, so that's why I say we got to educate the public about mediators and arbitrators out there, that's the first step before you go to court, is seek out a mediator, arbitrator first. It's going to save them so much money and time that it's going to be amazing. That some cases I've worked on, I'm even shocked when I resolve it in 15 minutes. I was like, that's all I had to say. So, and then some cases you go for 5 hours, 2 days. But some cases that shock you the most is the one that you think is going to be the most difficult one. Turns out to be the one that's settled in 15 minutes. So again, I want to leave and say, educating the community, the public, even government agencies, that mediation and arbitration is one of the quickest, fastest, and beneficial process before the court system.
Wonderfully said. I think after that, after that closing, we really do not need. And it's a pleasure. It's thank God I heard your podcast and I thought, you had posted it on LinkedIn and I thought, when I hear somebody talking, then I decide that, this person is good and I have to have this conversation. And I'm glad that I heard that podcast of yours and I brought you, invited you, and it's been great. It's been a pleasure to have this conversation. Thank you so much.
Thank you so much for having me, and it's great to be on this great panel with a great set of people on here.
Yes.
I call you my family on the other side of the world.
Oh, it's too good. Thank you so much, Jagdish
No problem.
and Kavita and Saloni also. She has a train. Are you inside the train now?
No, it's a delayed, so I'm still waiting.
That's one day we are going to thank the railway authorities to have given us that opportunity. Good. It was a
Mm.
lovely conversation, and thank God it was a lovely panel. Jagdish, Kavita, Saloni, George, wonderful.
Thank you.
Yes. Thank you so much.
Thank you.
God bless.
Thank you. Thank you. Thank you.
Thank you, everyone. Thank you so much for this opportunity.